This evening, we're going to focus on the legal professions, more specifically, lawyers and notaries. What's very interesting with the lineup of presenters that we have this evening, some are involved in the civil code jurisdiction in which we live, and others also have competence in common law jurisdictions. And so it'll be interesting to see that mix in some of the presentations. What I'm going to do is introduce everyone at the very beginning, very briefly, so that the session can flow very easily one from the other. And I'm doing it in the order of the presentations. Most of the people here are known, and if anyone is curious, you can find out lots of information on the web about them. But let me start briefly with my friend and colleague, Marion, with whom I've had the privilege of sitting on the board of the Spanish and on the executive committee, when she acted as a secretary. She truly is a very pleasant person to work with. Marion is a partner in the firm of O'Reilly and Dana, which is a small firm in the West Island, maybe small in size, but not necessarily small in importance. Marion received her education, first of all, at McGill, where she has a Bachelor of Science in Psychology. And I think that's a very good thing for the practice of law afterward, because you can understand your clients and understand their problems. And then she went on to do a Bachelor of Law at the University of Montreal, where she was involved in the Student Association and many other activities. After graduating from the University of Montreal, like all good Quebec lawyers, she went to bar school and survived that experience and is a member of the Quebec Bar, has been ever since 2006. So she spends a lot of time in court, in trial, defending her clients, and her practice is very much in the area of family law, dispute resolution, mediation, that type of thing. And she clearly, I think, is the example of what I mentioned earlier in one of the earlier sessions of the professional who is caring, who cares about her clients, who cares about her professional responsibilities. And she very often is involved in issues where she must protect the vulnerable. So I think it's a very important point. And so obviously you can see the link between what she does professionally and the issue of Jewish ethics, which she will speak about when she has her turn. Our second speaker is Alain Murad. Alain Murad is a member of the bar of both Quebec and Massachusetts, having worked in Boston for a while. And so therefore he knows both types of legal systems. He was obviously a student at the Faculty of Law at McGill University, graduated with distinction, it's no surprise. And he went on to do a management degree, an MBA at Concordia, after having completed, prior to his law degree, degree in business, Bachelor of Commerce at Concordia University. So he has a very good background in terms of the law, in terms of both civil jurisdictions and common law jurisdictions. And currently he's Vice President Legal and secretary for Reitmans Canada. Before he went into the private sector, working for a corporation, he also started out as a partner with Davies Ward, Phillips and Weinberg. And so he has experience both as a member of a firm, a very well-known firm in Canada, and also experience in the private sector. So Alain will bring to the discussion a lot of practical experience from that point of view. I might add also that Alain is the former president of the Association of Babylonian and Iraqi Jews, and also is a member of the board of the Spanish. Across the mountain, our next speaker comes from across the mountain, where he's a member of the Shara Shamayim synagogue. And we've always had very cordial relations with the Shara Shamayim. And Maître Malkinson also graduated from McGill with a degree in economics, and then went on also, like Marion, to the University of Montreal, where he did his degree in law, and went on actually to earn a master's in notarial law in 2014. Almost made you older than you really are. So he has a lot of educational background, which is very useful in the type of profession that he's in. And currently he is working with a notarial firm of Drazen and Friedman. And he's a member, like all practicing notaries in Quebec, of the Chambre des Notaires du Québec, and is obviously very familiar with the civilist type of environment in which notaries have to practice in Quebec. In addition to his involvement in various activities in the Jewish community, he also is a member of the Board of Trustees of the Lord Reading Society, which plays a very important role in terms of legal education. I'm going to leave the speakers' presentations at that. And when it comes to our Halakhic intervention at the end, I'll introduce our Chazan, Dani Benlolo, at that particular point in time. So without further ado, let's start with the presentation by Maître Marion Dana. Dana, Marion, it's over to you.
Thank you, Jim. Thank you for the kind words in the introduction. So as Jim mentioned, I'm a lawyer, and as you can see from the introduction page, I practice mainly in two areas, being family and elder law. So my education, so I'm going to tell you a little bit about my background, then I'm going to go more about our code of ethics, the code of ethics of lawyers, and I'm going to touch upon some cases that I've done. So my education, as Jim mentioned, I have a Bachelor of Science with focus in psychology, a major in psychology from McGill University. And I went on to do my Bachelor of Law at the Université de Montréal. So that is a Bachelor of Civil Law, which allows me to practice law as a lawyer in the province of Quebec. And I've been a member of the Quebec Bar since 2006. Since then, I've worked at 3 different law firms and dabbled in various areas of the law, which are, sorry, I just need to move around my screen. Okay. So I started with a firm called Jolie Carlacasse in downtown Montreal, where I interned. I did my stage. I worked as a student, then I did my stage, and then I worked 1 year as a lawyer, where I did various things such as Aboriginal and constitutional law. We worked on a very big case of Aboriginal law that was in the news way back in 2006. Administrative law, commercial law, disciplinary law. Disciplinary law is when we are dealing with issues about the code of ethics, so lawyers who could have potentially violated our code of ethics. I also did family law and labor law. And then I went on to a much smaller firm where I stayed for 3 years in Old Montreal called Cabinet Gamliel. that really handled immigration and civil law, pretty much it. I did a little bit of family law and elder law while I was there, but not very much. But then the firm where I am at now, which is my firm, and as Jim mentioned, I'm in the West Island. Our firm is called O'Reilly Dana. So there are two of us, my partner, best friend, and myself, where we've been together for 11 years. And my focus is family law and elder law. I've also done sometimes for some clients, I've done a little bit of youth protection. I'm sure you can see that touches upon family law, although I'm by no means a youth protection lawyer, and some general civil law as well. But the two areas that I find the most rewarding for me and that I enjoy the most, and again, you can see they touch a little bit on, or they're in say, relation to the fact that I have a Bachelor of Psychology, the two areas being family law and elder law. And by family law, for those of you who don't know necessarily what that is, so as you can see from the picture, it deals with families, so divorces and separation, custody. Some custody cases could be extremely high conflict, some less so. Oftentimes in family law cases, the biggest fights are over the children or alimony. So I also deal with issues of child and spousal support. Alimony is a synonym for spousal support. So child support is for the kids, spousal support or alimony is for the ex-spouses. There are also cases, sadly, of parental alienation. So where one parent will try to alienate the children from the other parent. So basically try to have the kids not talk to the other parent, and files can get very nasty, as you can imagine when it comes to divorces. And then there is the other aspect, which is elder law, which is, to me, the aspect or the area of law that I enjoy the most out of the two. And in there, we have things such as powers of attorneys or mandates in case of incapacity. So powers of attorney, when a person is still capable, but they want somebody else to act on their behalf to do certain financial transactions. The mandates come into play once that person has cognitive impairments and is no longer capable to do those acts for themselves because of a medical condition, whether physical or psychological. And at that point, we need to appoint a legal representative. So that's called homologating a mandate, and that's something I do regularly in my practice. Sadly, there are also cases of elder abuse and financial exploitation. So it could be financial abuse. It could also be physical abuse, psychological abuse, trying to isolate a senior. And those things can be done by family members, be it spouses, by children, but also by third parties, strangers that become friendly with an elder and take advantage of their vulnerability. So now I'm going to show you some principles that are listed in the Code of Professional Conduct of Lawyers. So what I did is I went through our Code of Ethics, and I just highlighted certain aspects of it that I wanted to talk about today in my presentation because I found that they spoke to me and they were important to me, but obviously this is just a sampling of many, many more. And so I'm going to list them all here, and then I'm going to go through them one by one, albeit briefly. So the first one is we have an obligation to uphold the protection of fundamental rights. We have the obligation to uphold the sound administration of justice. We have to act with honor, dignity, integrity, and respect. We have to obtain our client's consent before acting, and we have to pay particular attention to vulnerable clients. We must bear in mind limitations to our skills regarding the area of law that is involved. We have to dissuade clients from undertaking proceedings which are abusive. Of course, there is the importance of professional secrecy. We also have an obligation to advise our clients on other means of conflict resolution, so not automatically thinking about going to court. And we have to keep developing our knowledge and our skills. So the first one, and you can see the picture on the right of the Canadian Charter of Rights and Freedom. So it is very important as part of our practice, obviously depends on what area of the law that you do, but as a general rule, as lawyers, we have an obligation to help our clients when it comes to protecting their fundamental rights. And some of these rights listed in the Canadian Charter of Rights and Freedoms, there's also the Quebec Charter of Human Rights, are the right to life, the right to inviolability, the right to dignity, honor, private life, the right to freedom of religion, opinion, and expression, ensuring that there is no discrimination and no harassment. I'm making a parallel here with the principle in religion, loving thy neighbor, so ensuring that you do not discriminate against other people regardless of their differences from you. The right to a fair hearing by a tribunal. And there is a specific clause as well, which relates to me in my practice, that protects the elderly and the handicapped from exploitation. So that is provided for in the Quebec Charter. And moving on to the next principle, which is the sound administration of justice. So here, what is important to remember is that as lawyers, we have to ensure that the steps that we take in our files, in representing our clients, are proportional, so that we don't go overboard, not in a good sense. I don't mean we have to do everything we can for our client, but that, for example, when we're in front of the court, we don't file 10 motions when we could have just filed one. We have to maintain a proportional behavior with regards to what is being requested by our clients. And that is specifically set out in the Code of Civil Procedure, which was revised in 2016, 5 years ago, in order, and now it has a whole section about proportionality and how important it is. And also we have to cooperate with our colleagues, with other parties, with various witnesses and experts in the file. So this is a little bit of what sound administration of justice means. We have to act with honor, dignity, integrity, and respect. And again, that is whether we are dealing with our clients, with our colleagues, or before the court. So as you can imagine, when you're in front of the court, you have to be obviously respectful, polite. There's a certain way to act. But it's important to keep in mind that it's not just when you're in front of the court that you have to act that way, but you have to always be respectful, even when you're with your colleagues, even with your clients, when you're with third parties who are not represented. And I'm talking as a litigation lawyer. Obviously, I keep referring to the court and et cetera, and being in court. So I'm taking the perspective as a lawyer who practices regularly before the court. And it helps a lot to always try to get along with your colleagues. So for me, whether it's something that is prescribed by my code or not, I just find that it helps to resolve files, and there's no point. Our profession is adversarial enough, contentious enough when it is that there's no need to be disrespectful, rude with other colleagues. Unfortunately, not everybody practices that way, but it's something that I believe in very strongly, that my partner believes in very strongly as well. And it just helps everybody overall, and it helps the conduct of the file and the resolution, the positive resolution of the file. Something we must always keep in mind also as lawyers, and I'm going to talk a little bit about a case that I have that touches a little bit about elder law. It's important for us to ensure when we take on a mandate that we have our client's consent. Might seem obvious, but it's still something to keep in mind, but particularly when our client is vulnerable. I mean, I could say a lot more about client's consent, et cetera, but I'm going to focus on here on a client who's vulnerable, and I'm going to discuss briefly a case of elder law that I had recently. So in elder law, you can represent the elderly person, you can represent a family member. There are different parties who can make up a file. But what if the elderly person himself or herself needs representation, and there is, a potential incapacity, medical, cognitive impairment in that person, and then he or she comes to see you and says, look, my daughter is taking me to court saying that I'm not capable of making decisions. I need a lawyer. I want you to represent me. I want you to fight for me. So I had a case where something similar to this happened. And so I was representing the daughter. The daughter had a mandate for her father, what I referred to earlier as a protection mandate. She was worried that her father was, was spending his money excessively, but was spending it excessively because he did not have the ability to realize what he was doing, that he was spending in such a way that he was going to be bankrupt very soon, and that there was something maybe a little bit off with him medically. So we went to court to try to homologate the mandate, but before doing that, we needed to obtain medical evaluations and a social worker's evaluation, which is part of the way that it's done in such cases. But the father, who I will call Ned for the purposes of this presentation, believed that he was perfectly fine. He says, well, you know, I'm 90 years old. I can spend my money the way that I want to. It's my right. I saved it all my life. I can do what I want with it. The problem, and that's true. The problem is, while it may be true, it may not be okay if Ned is 90 years old, has X amount of money, but doesn't realize that he's overspending drastically, and that he is doing so because he has a mental, a cognitive impairment, to try to use the medical and legal term. So my client decided to have a doctor assess her father, a social worker assess her father. But Ned believed that he was fine, and he went to see a lawyer, and the lawyer represented him, went to court and said, no, my client is fine. And the lawyer himself did not ask that the court appoint him as attorney to represent Ned. He just assumed or believed that Ned was perfectly fine and started acting on his behalf before the court, before any evaluations were done, et cetera, et cetera. I'm going to move on to my next slide so that I can tie it in with that, and so that you can see how it fits in, and I can continue my story on with that. So not only do we have an obligation, as I said in the previous slide, to make sure that we have our client's consent and that our client is able to provide that consent, but we also have to keep in mind that we as lawyers may have limitations to skills and regarding the area of law that is involved. And if we have those limitations, well, maybe we're not the best person to represent the client who's coming to see us. So in the case of Ned, the lawyer who accepted to represent Ned was a commercial lawyer. He was not an elder law lawyer, but Ned needed a lawyer who knew what he was doing in elder law matters, in homologation matters. This lawyer probably did not care whether Ned was able to consent properly, but also this lawyer did not know what he was doing and would fight every little thing along the way. Things that were very basic in such cases, such as obtaining a medical evaluation, obtaining a psychosocial evaluation by a social worker, things that are very basic to any lawyer practicing in the field of elder law. That lawyer, being a commercial lawyer, fought us on everything, and it ended up costing Ned a fortune. And the reality is that we ended up getting medical and neuropsychological evaluations after, showing that, yeah, unfortunately, Ned has quite severe cognitive impairments that are perhaps difficult to see, but they're there from a medical point of view. And that lawyer, and as far as I see, that lawyer took advantage of Ned and did not know what he was doing, took his money, was not careful to make sure that Ned was able to consent, that he, the lawyer, knew what he was doing, just took the client to make money. And as far as I'm concerned, basically completely violated our code of ethics in so many ways. And I could go on and on and on about that one case, but I will leave it at that for now. Another thing that we have to keep in mind as lawyers is we have to advise our clients properly and tell them when we believe that the proceedings, the recourse they're about to take are abusive. Again, that goes back to upholding the sound administration of justice. And there are very specific proceedings in the Code of Civil Procedure of Quebec to that effect. So we cannot take clients down a path if it's abusive, because the consequence is that we as the lawyer or the client could be condemned to pay the cost. There is also the obligation to professional secrecy that is present in many code of professions, doctors, psychologists, etc. We have to maintain our client's professional secrecy, but there is an exception, and that is to prevent an act of violence. So when we are worried that our client is going to commit suicide or harm someone else, we are actually obligated to tell somebody and violate professional secrecy. And the parallel that I would like to make here with Judaism is, of course, the importance of the right to life, which we know is very important in our religion. And we see that it is important in the code for lawyers, and it is also present in the code for many other professions as well. We also have to remember to advise our clients not to think of court as a first means of resolving their conflict, because there are other means that they should look at, such as mediation or judicial settlement conferences, which is simply mediation in the presence of a judge at the courthouse. And these are often used in family law, such as in divorces. And this brings me to the case of Sharon. It was a client of mine, a woman who had been married for 20 years, and she was very, very clearly entitled to spousal support. We had gone to court twice to ask for spousal support on safeguard measures. It was rejected both times, to my complete and utter shock. So then we went to a judicial settlement conference. We basically lucked out in court. And that's what happens when you go to court, is a gamble. But then we went to a settlement conference with a judge, and the first thing the judge said to the lawyer and to the husband and to his lawyer is that my client is very, very clearly entitled to alimony, and what is the husband willing to pay? That was the beginning of the discussion. So sometimes it's worth looking at that and not going straight to court. And of course, the parallel that I would like to make here with Judaism is that it is very important in Judaism. Marriage is very important in Judaism, and oftentimes we see couples going to rabbis to maintain shalom bayit, to try to save their marriage. And in fact, the Divorce Act itself has the same idea that marriage is important. And as lawyers, we have a specific obligation when our client comes to see us for divorce, to file divorce proceedings. We have obligations to inform them that, to make sure they are certain that they want to go ahead with it, because even the Canadian Divorce Act believes in the importance of marriage. So we have to strive as much as possible to, both from me as a Jewish person, but also as a lawyer, to make sure that before a person wants to proceed with a divorce, that they are sure and that they know what they want to do before they go ahead. And the last thing that I wanted to mention,
Marion, you have about 5 minutes left.
Oh, I'm on my last slide, Jim. I know.
Okay,
thank you.
super.
I have a timer. Thank you. So the last thing I wanted to mention is that as lawyers, we have an obligation to continue to develop our knowledge and our skills. And in fact, it's a very specific obligation of having at least 30 hours of continuing education over a period of 2 years. And that starts up every 2 years. Starts again every 2 years, rather. And of course, aside from helping us become more knowledgeable and helping us be able to understand our files better and to plead in courts better, it helps us provide better service to clients. And I'm going to make a final parallel here with Judaism, which is the importance of education in Judaism. So we can see that in our code of profession, there is that importance, as there is in Judaism. We know that when we go to synagogue, on Shabbat, we hear the rabbi give a Devar Torah, and there are other times when, for example, we do Torah study, for example, the all-night learning for Shavuot. That Torah study is important, and we all know the importance of education in Judaism. And I'm personally somebody who loves to learn, as long as it's something that I'm interested in. But I'm interested in the law. I'm interested. There are a variety of topics that interest me in the law, in Judaism, etc. So this is definitely something that is right up my alley. And that's pretty much it for my presentation. Like I said, I chose different points in the Code of Ethics that spoke to me, that resonated with me, and that I was able to relate either with Judaism or with some of my cases. So if you have any questions for me at the end, I'll be around and glad to help you. Glad to answer your questions. Thank you all for your time and for listening.
Thank you very much, Marion. And I like the slip, you're ready to help.
I'm ready to help too. I am, right. I know, you're right.
So we're going to reserve our questions for the end. I have a number for you, and I'm sure everyone else does as well. But the segue that you provided for us in your presentation allows us to jump over to issues of commercial law. And so our next speaker, Alain Murad, is very much involved in issues of commercial law, especially with his employer Reichmann's. And now we turn it over to Alain.
Good evening, everyone. Thank you, Jim, for that warm introduction, and thanks to my consoeur and dear friend Marion for her very interesting presentation. and thank you all for being here and for listening. I will be presenting today on the topic of certain ethical issues that can arise in the context of being in-house counsel. These are sort of, as opposed to sort of the situation that Marion is in, where she's working for a law firm or her own law firm or another law firm, where you have a multitude of clients. In-house counsel has one client. That's the company they work for. So there are certain interesting ethical issues, ethical dilemmas that could potentially arise in that context. So I'll begin by sharing my screen. Okay, so these are ethical legal issues that arise in the context of being in-house legal counsel. Now, before I begin, I'd just like to say by way of disclaimer that the following presentation deals with legal ethical issues that could arise in the context of employment as in-house legal counsel. The scenarios outlined in this presentation should not be interpreted or construed in any way to be a reflection of the presenter's, that's me, the presenter's personal experiences, whether with his current or any other of his past employers or clients. Certainly hasn't been the case. These are just scenarios that potentially arise in the context of in-house legal counsel. And the presentation is offered solely for purposes of the Spanish and Portuguese learning series and should not be construed as legal advice. All right, so when you're in-house legal counsel, you wear multiple hats within the organization. You act as lawyer and legal counsel to one company. You are also a business partner and a business advisor. And you're also a senior executive and an employee of the company. So you wear multiple hats. And sometimes there are certain conflicts that can arise given these sort of different roles that an in-house legal lawyer plays within the organization. Now, it's always important to be aware and to remember what role you are currently fulfilling and to be vigilant to avoid conflicts of interest between these roles and your professional obligations. So as lawyer and legal counsel, company personnel must understand that it is the in-house legal counsel's first priority is as legal advisor to the company and not to any third party, including senior management or members of the board of directors. It's to the company itself that the lawyer owes its obligation. Now, where there is a conflict between the interests of the company and a third party and any third party, a lawyer's ethical responsibilities, duties, and obligations under the Code de déontologie must always take precedence. So as a business partner and advisor, one must be careful to clearly distinguish when one is acting in a business capacity and when one is acting in the capacity of legal counsel. There may sometimes be a conflict between what the business people want to do to generate profits and what in-house counsel deems a reasonable legal risk for the company to undertake. So a company may have, very creative business strategies, but the legal risk associated with those business strategies may be too great for the legal counselor to allow. So, and on the other hand, legal best practices, if you're plus royaliste que le roi, and you insist on very, very regimented by the book actions, this may be too obstructionist and constraining for the company to realize its strategic objectives. So there's always a certain level of inherent risk that's acceptable in terms of a business strategy from a legal point of view. And it's in-house legal counsel's job to find a reasonable compromise between accommodating the business people's creative strategies and an acceptable legal risk associated with those strategies, all the while acting within the law. So here are some issues that could potentially arise. These are certain scenarios, again, that could arise in the context of in-house legal counsel being employed with a company. Conflict of interest. So I'm going to be quoting certain provisions from the Code de déontologie because I'm a member of the Barreau de Québec, but various other bars have very similar provisions. So as far as conflicts of interests go, in the Code de déontologie, a lawyer must avoid any situation of a conflict of interest. there is a conflict of interest where there is a substantial risk that the lawyer's own interests or his duties to another client, a former client, or another person, I mean any other person, would adversely interfere with his duties to the client. That's the company. So the in-house legal counselor always has to be conscious of who is the client. And one of the principal ethical challenges faced by in-house counsel is identifying who the client is. In-house lawyers represent the company, which is their client, and not a near client, such as the company's officers, directors, employees, shareholders, agents, or even the company's affiliated entities. It's the client, it's the company itself, the legal entity itself that is the client of the in-house lawyer. So when receiving instructions from a near client, the lawyer must always be acting in the best interests of the company, which is his client. So here's an example. A senior executive of a company operating in the aviation industry, say S&P Airlines, suggests to in-house counsel a company offering pre-packaged flight meals. Let's say this company is called Fly-by-Night Foods, as a potential contract. We have a senior executive of a company called S&P Airlines, and he suggests to the in-house counsel of S&P Airlines, well, why don't we enter into contractual arrangement for prepackaged flight meals with this company called Fly-by-Night Foods? Now, the senior executive doesn't mention that the CEO of Fly-by-Night Foods is a close personal friend, and that he has a personal stake in Fly-by-Night Foods. Okay, so you can already see sort of a conflict arising. Now, Fly-by-Night Foods, to top it off, does not enjoy the best reputation for prepackaged flight meals. However, the senior executive makes a very strong push with in-house counsel for S&P Airlines to retain Fly-by-Night Foods as their in-flight service meal provider. As in-house counsel, the lawyer must serve the best interests of the company, not the personal interests of the senior executive, and cannot allow his independent judgment to be affected or obscure the legal, business, or practical advice he's giving to the company. Now, you can understand that in certain situations, and there have been many public situations, sort of scandalous affairs that recently took place with certain Quebec mining companies, for example, where there's a lot of these sort of pressures to enter into contractual arrangements. And it may often be difficult for the lawyer to resist these ambient pressures. It could, if he refuses, for example, could it jeopardize his employment or prevent corporate advancement? Now, these are things that in-house legal counsel needs to be sensitive to, always acting in the best interests of the company and not the best interests of any other party, notwithstanding the seniority of the position they may occupy within the company. There is a duty of candor and honesty. A lawyer must act with honor, dignity, integrity, respect, moderation, and courtesy. A lawyer is honest and candid when communicating with clients or advising them. So a lawyer is required to be honest, candid, and fully transparent, and advise the company on all information and issues relevant to a legal matter. This means that the lawyer must deliver all relevant information to the client company, even if it's bad news that senior management or its directors do not want to hear. So here's an example. In-house counsel at S&P Airlines, we'll use the airline S&P Airlines, must bring corporate executives up to speed on impending new airline safety regulations, which are going to affect how S&P Airlines conducts its business. Now, the lawyer receives a lot of feedback, right, from certain affected employees within the company who pressure the lawyer not to press the issue of the new regulations with senior management, because the new regulations present additional regulatory barriers that may make it more difficult for them to achieve their financial business goals. In-house counsel cannot be tempted to withhold negative information or provide opinions to appease the company's employees. He is required to be honest, candid, and fully transparent, and advise company management on all information and issues relevant to a legal matter, even if it may disrupt current business strategies. Another area where potential conflicts or potential ethical issues arise surrounds the confidentiality and solicitor-client privilege, confidentiality of communications and solicitor-client privilege. Whereas the practice of the profession of a lawyer is based on the following values and principles which a lawyer must take into consideration in all circumstances. This is in the Code de déontologie, in the sort of the preamble. Loyalty to clients as well as protection of their legitimate interests and the confidentiality of information concerning them. Then it says a lawyer, in section 20, a lawyer owes his client duties of integrity, competence, loyalty, confidentiality, independence, impartiality, diligence, and prudence. And a lawyer must ensure the confidentiality of all information concerning the affairs and activities of a client of which the lawyer becomes aware in the course of the professional relationship. Now, the issue of solicitor-client privilege is somewhat more nuanced in the context of in-house counsel. When a company is communicating with their outside counsel, it's almost implied that their communications with outside counsel are privileged and confidential. When it's done with in-house counsel, because there's this employee relationship, because there's sort of a co-employee relationship, it's not as clear. So it has to be very, very, very carefully tailored communications to ensure that solicitor-client privilege is retained. So because of in-house counsel's multiple roles, application of solicitor-client privilege to in-house counsel's communication often depends on context. Now, solicitor-client privilege protects communications between in-house counsel and company personnel when the communication is between lawyer and client. So it's a lawyer acting as in his capacity as a lawyer and the client. The communication is intended to be confidential, and the communication is for the purpose of seeking or receiving legal advice. Okay? But there is a trap that employees could potentially fall into. They're called the CC trap. So copying in-house counsel generally on emails or other written communications does not protect those communications if the sender is not seeking legal advice. So if the sender is communicating with a bunch of other employees and he's not really seeking advice, but he CCs the in-house counsel, that communication is not privileged. It could potentially be discoverable, even if it has, content that could potentially harm the company. It's difficult to say that it's privileged communication because it wasn't necessarily seeking legal advice, and a whole bunch of other people were CC'd on. And indiscriminate copying of communications throughout the organization, indiscriminate copying of communications throughout the organization of communications that otherwise contain privileged information may result in a loss of privileged status. So that sort of goes back to the example I just gave. If you're communicating with your lawyer and you're seeking legal advice, but you're CCing a whole bunch of other people who aren't your lawyer, that's potentially problematic, and that could cause privilege to be lost. So it's really important to remember that when advising internal employees in writing, by email, in-house counsel should send business and legal advice in separate communications and only to personnel who need the information. In other words, there shouldn't be this broad dissemination of information because it's difficult to argue that it's privileged and confidential if everyone gets to read it. And if the communication contains legal advice, it should be marked eternally client privileged and confidential, do not forward. So that's an extra peg to hang an argument on, that that information is intended to be kept confidential and is privileged communication. And it's very important to educate employees about the importance of privileged and confidential communications. All employees should be made subject similarly to confidentiality arrangements. In fact, most companies do subject their employees, especially their senior employees, to confidentiality. So here's an example. An employee of S&P Airlines is in receipt of a demand letter by the CEO of Fly-by-Night Foods. Probably he's very upset that he didn't get that contract, alleging infringement of one of Fly-by-Night Foods' trademarks. So now you have an employee of S&P is getting this demand letter from the CEO of Fly-by-Night Foods, and the CEO of Fly-by-Night Foods is saying, you infringed my trademark, and he's making all sorts of monetary demands. So the employee is, very nervous and scared, and he communicates the letter to the in-house counsel and he solicits his counsel's advice. So far, so good. The problem is that in the communication, the employee makes an admission and CCs several other colleagues and friends to warn them about what took place so that they do not make the same mistake. So, he could, in the email to the lawyer and to everyone else, he says, well, you know what, he's actually right. I may have used portions of his trademark. He's really, sort of unique components of this mark. And I'm just putting it out there. This guy, the CEO of Fly By Night Foods. He's one tough hombre, and be careful. Don't make the same mistake. And by the way, Mr. In-house lawyer, what do I do? Now, the employee's intentions may be good, but attorney-client privilege is compromised because a whole bunch of other people know about this now. And there's an admission that's been essentially communicated to people who are not, legal counsel. Another issue is that a lawyer must not claim specific qualities or skills relating in particular to his competence or to the extent or efficiency of his professional services unless he can substantiate those claims. So, in-house legal counsel may often be asked to opine on all matters relating to the company's legal needs, even complex issues that fall outside their particular area of expertise. So this is potentially problematic, and the lawyer has an obligation to say, hold on a minute, this is not my area of expertise. I have a background in intellectual property law, so I may not be qualified to opine on issues relating to family law. I would refer someone to Marion for that. We are not the Oracle of Delphi. In-house legal counsel must be prepared to tell senior management when the expertise of outside counsel is required, even if it means incurring extra legal expenses. So in-house legal counsel at S&P Airlines who has a background in air and space law, right? So he's working for an aviation company, has a background in air and space law, and he's asked a question by a senior executive of the company on an issue relating to international taxation that can entail significant cost savings for the company. But the lawyer can't purport to provide legal advice on a matter such as this, even if pressured to do so to save money on legal fees, and must retain the services of outside counsel to provide the advice. So those are certain issues that could potentially arise in the context of in-house legal counsel. And those are essentially the ethical obligations that an in-house lawyer has to be sensitive to. So with that, I'll pass on the baton to the next presenter. And I thank you for listening, and it was a pleasure to be here. Thank you.
Thank you, Alain. So my question is to both you and Marion. Are you practicing psychotherapy without a license?
I am.
Both of your practices are very much rooted in dealing with the different types of psychological pressures that exist within the work world.
You have no idea.
I can imagine. We wrote the regulations for psychotherapists, so I do have some grasp of what you're talking about. So speaking of those types of tensions, we'll move on to a notary now. And notaries are also very much involved in negotiating sometimes very tense situations, etc. So I'd like to pass it over to William, who's going to talk to us about the practice of notarial law in a civil jurisdiction in Quebec.
My presentation is going to be a little bit different from the first two. So basically, one similarity with the other presenters is I'm going to go through my role in the context of civil law. But in the second part of the presentation, I'm going to give you some case studies that actually intersect with Jewish law, and I hope it'll sort of segue into the Cantor's remarks with respect to tonight's presentations. So the role of the notary in the context of Quebec civil law, number one, we're an auxiliary of the judicial system. So which you'll see in my next slide, I'll go through exactly what that means. We're also a public officer, similar to lawyers. We act very often as an escrow agent, and fourthly, as legal counsel. So with respect to being an auxiliary of the judicial system, the court often will delegate certain court powers to the notaries. We see this, number one, with homologating mandates, similar to what Marion touched on, although the process is a little bit different. So when Marion homologates a mandate, she does it through the court system. Notaries, since 1999, actually have the ability to homologate a mandate in-house. So there's a whole notarial procedure which runs parallel to the judicial procedure of homologating a mandate. We also are able to probate wills that are not notarial in form. So under the Civil Code of Quebec, there's three forms of wills. You have notarial wills, which don't require probate. And then you have wills executed before two witnesses, which do require probate. And lastly, holograph wills, which also require probate. So we are actually able to in-house probate that without a judgment from the court. So what we call minutes of probate sort of are in lieu of a judgment, okay? Similarly, as well to Marion's practice, we have the ability to institute protective supervision regimes, either in the case of a minor who's inherited an important sum of money, or again, similar to Marion's cases, in the case of a adult who's become incapable, okay, so who's lost their mental capacities. Lastly, we have letters of verification, which is the use of a will executed in Quebec outside of Quebec. So say if a particular person, a deceased, had property outside of Quebec, and we have to prove to the authorities outside of Quebec, that this was the last will and testament, that these are the heirs, this is the liquidator, we use letters of verification. And again, I don't require court intervention, so to speak. So I don't require intervention of a court clerk or a judge to complete that process. With respect to being a public officer, so I'm empowered to emit authentic acts, whether they be en brevet or en minute. So the difference between an en brevet deed and an en minute deed, both are authentic. The en minute deeds, I keep the original in my safe to make copies whenever the parties request it. En brevet deeds are authentic deeds, but the copies are made on the spot and the signatures are all signed on each copy. So what makes a deed authentic? Well, number one, it's presumed valid and regular as far as its execution. It has probative force, makes proof of their contents, i.e. the date, the signatories, and capacity of the parties. And data certa, which basically the contents are fixed and unalterable. So once I execute, or once one of the parties signs a minute or an en brevet deed, can't be changed. With respect to being an escrow agent, this is mainly for transactional security. our trust accounts also maintain transactional security. So for example, if I have a real estate transaction, I'm acting as an escrow agent. So I make sure that all the funds prior to a real estate sale, or in the case of a refinancing, are in my trust account before I pay, the vendor's mortgage, or pay the vendor his proceeds of the sale, or in the case of a refinancing, to pay the prior creditor and obtain a quittance before giving any balance to the debtor. And of course, the impartiality of the notary, which I'm going to touch on in the later slides. Lastly, notaries act as legal counsel. So a notary's training in Quebec, they have to go through a master's program after going through a law degree. So you can say that on the one hand, the legal education of a notary is very broad, having gone through law school, and then it becomes highly specialized in the master's level education. So again, my areas of practice are mainly real estate sales and financing, non-contentious procedures, which I went over, and some estate planning. So with respect to the Code of Ethics, I took from the Notarial Code of Ethics and the Notarial Act a few articles which I thought would be important for the purposes of this evening's discussion. So number one, every notary shall act with dignity and shall refrain from using methods or adopting attitudes likely to detract from the good repute of the profession or from the notary's ability to serve the public interest. This is very similar to the lawyer's code of ethics. Secondly, every notary shall consistently strive to maintain up-to-date knowledge of his profession. Notary shall always remain informed of developments in the areas in which he practices and shall maintain his skills in these areas. So similar again to the parallel which Marion touched on. Education and furthering education is very important in the legal field, no different in the notarial field. And obviously, parallel to Jewish values, Jews place a very high importance on education in general, whether it be secular education or Torah education. No notary shall conclude an agreement that could jeopardize the independence, impartiality, objectivity, or integrity required to practice the notarial profession. A notary shall avoid all situations where he could have a conflict of interest. This goes back to the impartiality and also the neutrality of the notary. And the advice given by a notary to clients or to parties to an act must be disinterested, frank, and honest. Okay. One of honesty also very important aspect in Judaism. And the independence as well. Notaries have to maintain that independence when dealing with respective parties. So we continue. Every notary shall seek to establish a relationship of mutual trust between himself and his client. To that end, he shall in particular refrain from practicing his profession in a perfunctory manner. And number two, conduct interviews with respect for his client's values and personal convictions. So number two is going to find its way into one of the case studies, which I'll go through later on. Basically, again, we have to act in a professional manner, okay, without denigrating the profession. No different, than a Jew would act as far as the religion. We always have to be mindful how we're carrying ourselves. For example, I always, my kosher friends, if they go into a Starbucks or a non-kosher place, they might remove their kippahs or put a hat over their kippah to not sort of lead anybody into error. Another Jew thinking that this particular institution or whatever might be kosher or whatever. So the case studies which I'm going to go over here with respect to Jewish law and notarial practices, I have two tonight. One is with respect to loans and mortgages, and the other is with respect to wills and estates. So loans and mortgages, a very interesting area for me. We all know the stereotype of the Jewish moneylender, okay, which is fine when the money is being lent to a non-Jew, but certain problems arise when there's a loan being made between Jews. So the Torah and Talmud encourage lending money without interest. The interest in Hebrew, ribis. The original interdiction was with respect to all religions. So originally Jews were not supposed to lend money with interest to any Abrahamic religions. There was then a clarification by Rabbi Isaac Barbanel, and later in the Shulchan Aruch, that this interdiction was not applicable to other faiths. Okay. The Torah says that civil action cannot be launched against someone owing interest under the penalty of death, meaning that if a creditor tries to invoke an agreement and sue for interest against another Jew, it's punishable by death, which shows just how serious this transgression is. So how do we get around this? Very interesting. Over the course of the Middle Ages, this institution called the heteriska, which is literally an exemption contract in English, which is a mechanism designed to permit profit being gained by a lender in a business transaction between the lender and the debtor. Okay. Basically, the parties agree that the proceeds of the funds will be used by the borrower for a business venture, the lender being the investor and the debtor being the manager of the venture. The investor and the partner lender earns a profit equal to the interest rate charged on the loan. Remember, this interest rate is sort of a fictitious interest rate. And the sharing of this profit does not constitute ribis, so to speak. Contained in the heteriska is downside protection for the lender. So meaning that no matter how the debtor uses the funds, the proceeds of the loan, there's no downside for the creditor. He's always entitled to his, so to speak, profits from this business venture. So again, other ways to get around this interdiction of not lending with interest to another Jew, which I've seen in my practice. So a Jewish lender will partner with a non-Jew, and the initial loan will be made by the non-Jewish lender to the Jewish debtor. And then subsequently, the loan will be transferred by the non-Jewish lender to the Jewish partner after the fact. This is done out of the control of the Jewish debtor. Now, very religious Jews will not accept this workaround. It's questionable, so to speak. Although in certain cases, and we have to make sure that the creditor transferee, so the Jewish creditor who's receiving the cession of the loan, is not a religious Jew either, because again, they won't accept this workaround. Then we have the question of what happens if the lender is a corporate entity controlled by a Jew. So under civil law, corporations are considered separate entities from their shareholders. So the question arises, if a corporation makes a loan to a Jewish borrower, and that corporation is controlled by a Jew, is this halakhically okay? And again, I've seen in my practice, for some, it's okay. For others, there's sort of, if I can use the term that comes from civil law, there's a piercing of the corporate veil. And, it's not acceptable for the Jewish creditor or borrower to use this mechanism, but it still exists, and many will accept it. So moving on to wills and estates. One of the particular issues that we can face when drafting a will for somebody, a Jewish person, usually obviously a Jewish person who's not so connected to their Judaism, is this desire that they be cremated. Now we all know in Jewish law, cremation is not allowed, it's prohibited. And there's this idea in Jewish law that a Jew who enables a transgression is guilty as much as the transgressor. So going back to one of the slides under the Code of Ethics, this is in direct conflict with the Notarial Act and my obligation as a notary to render judgment-free, value-free service. Okay, and remember something: when lawyers and notaries are rendering their service, they're rendering, especially under this CAC government, which we're currently living under, we're rendering this service in a quote-unquote secular state. Okay, so this is always in the background of our service. Okay, question then becomes, how do we get around this? So a lot of notaries, when they're faced with this type of issue, will simply recuse themselves because, and again, it depends on how religious the notary is, but if they do not want to aid in the transgression of cremation, then they'll simply say, execute the will elsewhere, or have, a non-Jewish notary execute the will. So now I'm moving on to successoral law. So the successoral law under Halakha, Torah devotes 6 verses to the laws of inheritance. This is in Bamidbar 27, 5 to 11. Male offspring are exclusive heirs of their father's estate. So under the Torah, women have no right to inheritance as long as male heirs exist. And they may inherit in the case where there's no male offspring. Okay, so the default is if there's male offspring, they inherit to the exclusion of all the daughters. The Torah does provide for this idea of representation, meaning that if a child predeceases and leaves lawful issue, that lawful issue will inherit. Then we move on to this idea of a Bechor, which is a true firstborn male, which is entitled to a double portion under the Torah. So if you have a true firstborn male, by Halakhic law, he is supposed to inherit twice as much as the other males in the family. Under Jewish successoral law, a ketubah, so a Jewish marriage contract, should provide for the needs of the widow. Support and maintenance of unmarried daughters is provided for by the male heirs. So the male heirs inherit with this natural obligation, legal obligation to support their sisters until the time in which they are married. So one of the issues that we often face in our practice is what happens when a very religious person wants to make their wills in accordance with halacha. So again, one of the workarounds that I see in my practice is we will prepare a will to the strict directions of halacha, and then we'll prepare sort of a counter letter which will make other directions. So a kosher will is prepared, and then the testator will indicate to his male children that they should gift a certain portion or an equal portion out of their inheritance to their sisters. This is something that I've seen. Now, it's very important to note that the Jewish successoral law is in sort of direct conflict with Quebec intestate successoral law. So in the case where a person dies without a will in Quebec, the Civil Code of Quebec dictates that his property will be split 1/3 to the spouse and 2/3 to the children, irrespective of whether those children are male or female. And again,
sorry to interrupt, but you have about 5 minutes left, okay?
And again, touching also on one of Marion's slides, we also always have to govern ourselves in our legal practice, with the law of the land. And there's this idea in Judaism also that, we must adhere to the law of the land. It's very important. This exclusion based on gender in Jewish law is in direct conflict with the Quebec Charter, Article 10. And so it's very important when we are making a quote unquote Halakhic will that we don't stipulate the reason why the daughters or the women in the testator's life are not inheriting. So in Quebec, we have this idea of freedom of willing. So a person can disinherit whomever they like, but they're not allowed to give a reason for disinheriting, which is derogatory, which is contrary to any of the principles in the charter. So for example, if a gentleman has 2 children, let's call one Moshe and the other one Rachel, and his will stipulates that all of his property is going to Moshe and nothing else, it's perfectly fine. Now, if he says in his will that all of his property is going to Moshe because this is what Halakhic law stipulates, that, you know, his daughter should be excluded, there his daughter might have a possible court challenge against having the will annulled or that article struck out, because the intention of the testator to exclude based on gender is clearly noted. So this is something that we always have to be aware of when we're drafting a halakhic will, not to give too much insight into the reasons why somebody is not inheriting. Now, very interesting, when I was telling my secretary today a little bit about my presentation, you know, she asked and pushed it sort of one step further and asked me, could there be an implied intent? Meaning that based on the facts, even if we don't write anything more and we say, you know, only Moshe should inherit, can the facts surrounding the testator, meaning that, you know, here's a religious Jew, and we know that under halakhic law, daughters do not inherit, could a court possibly take it amongst themselves to imply an intent on the testator's wishes? And I found that to be a very interesting question. And so, you know, I leave the door open to a possible challenge on that level, meaning that, you know, that a court might imply an intent, which might not be written black on white in a will, but based on the facts and circumstances surrounding the drafting and the testator himself or testatrix, that this could be implied. So that's really the end of my presentation. I hope you enjoyed.
Thank you very much, William. Thank you. That's practicing law in a secular state.
Yes.
Very good issue. And it allows us now to segue into our next section, where we are going to ask Chazan Benlolo to comment on some of the halakhic issues which have been raised in the various presentations. We all know Danny Benlolo ever since he's been a very young man. At least I know him since he's been a very young man. And he started actually as a Chazan at the Spanish and Portuguese synagogue when he was only 17 years old, because he came from a family where music was part of family life. And he's the personification of that. However, he did go on to study, and he studied Chazanut at the Bells School of Jewish Music in New York. And he was able to learn many different traditions. And when he worked in Ottawa, he certainly served as Chazan with Ashkenazim. And now he's back home in Montreal and working with our community here and making sure that the traditions of Sephardi Chazanut are maintained within our community as well. In addition to being Chazan, Danny also received smicha in 2017. So, in fact, he is in a position to comment on some of the halakhic issues that have been brought up in the various presentations. I don't know if he's going to give us a psak din on all of these issues, but certainly he's capable of leading a discussion on those issues. He's also very much involved in community and very much involved in what I would like to call intercultural relations. So he is not blindsided by a particular Jewish view of the world. He's open to many different perspectives and has worked with a lot of people from different backgrounds. And so therefore, one of his strengths is the openness of his mind and the creativity of his mind and his ability to work with all sorts of people. The other thing which I think is important when I think back of the discussions that we've had so far today about protecting vulnerable people is that he's very concerned with certain categories of vulnerable people. And in his professional life, he's devoted a tremendous amount of his own personal time and professional time to protecting certain segments of our population, which we could clearly consider as vulnerable. So, Danny, I'm going to pass the mic over to you and allow you to comment on some of the issues that have been raised by our presenters so far that could be interpreted from different points of view, different halakhic points of view. Danny, the floor is yours.
Thank you so much, Jim. I really appreciate the invite. And I have to say a big yashar koach, hazak ubaruch to our presenters. I just want to piggyback on what William just finished with, which is very interesting because it is very apropos. We just finished reading from Parashat Pinchas this past week, and we're talking about, the men receiving the rights and the wills, and women were set aside, if you want to say. And very interestingly, because we were talking about Benot Tzelofchad, the women of the 5 daughters of Tzelofchad that were looking for their inheritance since they had no male representatives in their family. And they were given the right, and they actually, it was interesting, some of the interpretation says that God was proven wrong at this time, Hamavdil. He was saying, we have the rights. They went to Moshe. They said, you know what? We don't have a brother, and we have the right to own some of the land. And the daughters of Tzelofchad saw that they would not receive that portion. And in distress, they went to Moshe and asked him, and presented their case, and they won. So I'm wondering if William, is that a grounds for changing the law, and is that a possibility, or is it something that we should be looking into? It's a question, but it's a very legitimate question. But in the meantime, is it something that could be cross-referenced as church and state, if you want to call it, so you can't mix both? Is that a question? Is that something that you would see as a possibility or an opening?
I think, listen, we always say in law, and I'm sure Marion as as somebody who goes before judges regularly, you can have a case put before 3 different judges, and you'll get 3 different
That must
answers.
be 3 Jewish judges then.
Well, the legal system is not perfect in that sense, so, and there's many legal scholars, secular legal scholars, who have always said, as much as judges try not to impose values and subjectivity on a judgment, there's always sort of, if I can use the term, a leakage of somebody's baggage, somebody's background, somebody's history in a judgment. So it's sort of an impossible question to answer in a certain sense, but I don't negate it completely. It's certainly something that...
Can I offer a little comment to piggyback on you? on
Please.
your comment. It's I read entirely the Pinchas parasha because I have a book at home, and apparently, well, in this case, as William stated, if there is no male representative, so in that case, of course, it was adjudicated by God and then through Moses. But also in the parasha, if we're going to really talk spiritually now, not only halachically, I'm veering towards another direction, but not too far, don't worry. It says that God intentionally left that part out because he wanted it to become showcased as it came up.
Mm-hmm. Interesting.
Sure.
Yes, thank you very much, Sandra, and thank you, William. I have. First of all, I wanted to clear one thing. I don't know how many hockey buffs are out there, but I want to make sure that I'm legally covered by knowing that I'm the only one standing between myself and yourself and the hockey game. So if anybody wants to stop me from talking at a certain point, please do so, because I don't want to be one standing in the middle. First of all, let me explain.
Sorry, Danny. The only comment is that we have to leave a little bit of room for some questions afterward.
Okay. Okay. So I'm not going to go very quickly, but I'm just going to step out very quickly to ask you one very important question. I'm a Cantor. I'm a Chazan. I did have my smicha, but I'm also a clergyman that does a lot of life cycle events, tries to keep the peace in families and everything. I had the opportunity to delve into many different patterns and ways of creating bridges between people. I do also get very often in my office people and families that have family discords. And when they do come, it's monetary discords. And sometimes because somebody passes away in the family and there is inheritances, this one took more, this one is taking a little bit less. I want to know why. There's family involvement. There's a lot of sentiments. There's a lot of pain that is involved. And I've had the opportunity throughout my 37 years in the clergy life to see how divisive not only money but also character can come in the way. And when I listened to Marion speak about all the fragility of helping individuals, acting with derech eretz, ve'ahavta lere'echa kamocha, to love thy neighbor as thyself, to love the other person. And also Alain was touched upon it. William definitely spoke about that too. The whole concept is really under the Pirkei Avot, the ethics of the fathers, the Shulchan Aruch, which is a guide when we talk about Maimonides' guide to the perplexed. So many different Halakhic interpretations have gone through all of this, and I'm wondering if the code of law that is now adopted in either in the States or in Canada or anywhere, but most of it, or the fundamentals of it, have not been taken from all of these great works. If we are able to take medical advice from Maimonides, from Maimonides, why can't we take some of the important laws and fundamentals of the law through traditions, through what we have been gifted with? So halacha, in definition, is the body of Jewish law supplementing the scriptural law and forming especially the legal part of the Talmud. And of course, we all know that when you're talking about the Talmud or the Gemara also as it stands, when, the whole concept, in plain stories, you dig a hole and then your cow falls into that hole. Who is responsible for the damage to that cow? Is it the person who dug the hole, or is it the person who didn't create a fence around that hole? So there's so many different ways of approaching a legal obstacle that it brings me to say, "Al shlosha devarim ha'olam omed." On three things the world is based on: ala Torah, ve'ala avodah, ve'al gemilut chasadim. And when we look at them, the Torah, ala avodah, ala Torah is the law, given law by God, by the Rabbanim, the rabbis that instituted such laws to create what we call a fence around the law. So example, i.e., why do we respect or follow laws that are not even written in the Torah, but are derivatives of the law, meaning that we are not allowed to repair something. So we are allowed to ride a bicycle, but if it breaks, we're not allowed to repair it. So because of that, we're not allowed to ride the bicycle. So then I think, William, you touched upon something that I noted that has to do with, marat ayin, somehow the perception in the wills and everything, the way it was worded, the way you mentioned it, a lot of it to do in Jewish law, it's called marat ayin, the perception of something that might not be what it actually is. For example, going in, like you mentioned, to a restaurant with a kippah on your head, the perception is, yourself, you're not going to eat at that restaurant, but when you're going into that restaurant, somebody who sees you will have the perception that you went into that restaurant, and look, that person who is a religious person is eating in a non-kosher restaurant. Same thing with a woman who's covering her hair, because she has to cover her hair when she gets married, the religious woman, but now is using a $5,000 wig with natural hair. Is it permissible, or is there something that you're going to say, well, hold on a second, I'm not supposed to be attracted to a woman's hair, but the wig that she's wearing is nicer than her actual hair. So there is this whole concept of marat ayin. So in everything that everybody said, I was listening, and I was like really very pleasantly surprised that it was it's a lot to do with the root of the Torah. And I'm going to stop there. And I know that we have some questions and answers, and we can go on all night with this, even after the third period. Go ahead, Jim.
Oh, Danny,
This is not Leil HaShavuot, so we have to leave some room if there are questions from anyone else. You don't mind? Sandra, if anyone else has a question.
I just wanted to say he's such a bridge builder, and because women work too now, not like before. So what he's saying is very deep, and he has the courage to put it out there and say, well, why can't we change this to go with the times?
Thank you.
Thank you.
Thank you.
In fact, Danny, you could have given the root of the word halakha. What does it actually mean? The verb.
Well, halakha is actually it's hilchot. I mean, it's the foundation, which is probably more a body. It's the body, and then halakha of the law. So it's the body of the law. That is the root of the word halakha. Mm-hmm. It's not like when we talk about Kabbalah means to receive. Halakha is more of the exterior concept of the law, which is all the nitty-gritty stuff of the law.
You passed your exam. So
I remember those days.
So I'll wrap it up with one question, which cuts across all three presentations, and even.
Sorry, I just wanted to say that Alain Murad, it was such a wonderful thing that he included the incident where he stood tall and he said, I don't do this on Rosh Hashanah. And for me, that was one of the pinnacles of tonight's lecture.
You're the Sandy Koufax. You're the Sandy Koufax here. Yeah.
Oh, sorry.
So,
Danny, we love
so-
you.
so he has koach. That's the
Yeah.
important part. So that's a play on Koufax.
Oh, very good.
Okay, so the wrap-up question for everybody is that if we look at the code of ethics for the notaries and for the lawyers, one of the big issues, especially in civil law jurisdictions, and this is true of halakha as well, is what in European law is called the right to understand. So the client, for instance, if the client is having a will drawn up, or Alain is giving advice to a recalcitrant businessman, or Marion is trying to solve a family dispute, etc. What's important is that the client actually be able to understand the implication, the legal implication that is concerned. So that just as a rabbi, when he's presiding over a marriage and the couple are signing a ketubah, it's a legal document. And do they actually understand it? And what is the obligation of the professional to make sure that the client actually understands the contractual situation into which he or she is entering? Alain, do you have a point of view on that?
So there are provisions in the civil code which deal with defects in consent. And there are certain instances where consent can be vitiated, where the individual doesn't understand what they're doing. So I remember, I'm harking back some 20-something years, but there was an interesting case called Yoskovich versus Tabor. I don't know if Marion or William remember this case from law school, but it's interesting because it concerned a member from our own community. And it was a family that sold a cookie business to their domestic, who barely spoke English, and I believe she was Hungarian in origin. And the cookie business consisted of a couple of recipes and a couple of pots and pans, and they sold this cookie business for $50,000. Now, this is one of those instances where it was a contract of adhesion or a contract between a major and a minor, or a consumer contract, or any of these instances where consent can be vitiated on the basis of statutorily defined instances. But it turned out that the person clearly didn't know what they were doing when they contracted, and so the court vitiated consent and nullified the contract. So there are provisions in the code dealing with sort of these unconscionable occurrences, and courts do have discretion to nullify even contracts that, by all appearances are valid contracts. But I don't know if there's a specific, if it's specifically delineated a right to understand. It sounds very European to me. Even in a civil law jurisdiction. But there are provisions dealing with that.
Marion, do you run into problems like this?
So do you mean the right to understand what the lawyer is telling the client? Is that what you're referring to?
Usually what it means in European legislation is that the client, if there's a document which is being signed, okay, the client has the right to actually understand the content of the document, and the jurist responsibility is to ensure that the client actually does understand.
Yeah, okay, that's what I understood from your question.
Right.
And yeah, of course, that's a huge part of our role. So in more so in family law than in elder law, because in elder law, there aren't often documents like consents, agreements to sign, but very much so in family law and divorces. And divorce agreements range anywhere from like 5 to 12 pages. Might not seem much for corporate lawyers, but for somebody who's divorcing and agreeing to things about how to separate their assets or things in relation to custody and payment of support, etc., it's quite lengthy and detailed. And sometimes the language is, it's certainly not lay language. There are clauses at the end that are more complex. So yeah, we absolutely do have an obligation to ensure our clients understand before they sign. Even a simple matter like what I was referencing earlier in my presentation, we have an obligation to understand our clients consented to our mandate. And by that, I mean, my clients sign a fee and mandate agreement. So I need to make sure my clients understand. I sit and I read through my fee and mandate agreement with them, read it out loud with them. I ensure that they understand the contract between me and them, the relationship between lawyer and client. So even from the get-go, something as simple as that to anything more complex along the way, I will never allow my client to sign anything if I have any doubt that they don't understand, that they're uncomfortable signing. I've had 2 cases that come to mind recently of divorces of elderly clients, and both clients came accompanied by their adult child, by their daughter and son in another case. And in one case, one case was very clear. The woman was super sharp. Her daughter was there to accompany her, but she was sharp. She was making jokes. She was completely with it. I had no questions that she was okay to sign. But another one, I was worried that the woman would not be able to sign because she was potentially starting, signs of dementia or something. And I did not feel comfortable with her signing at all.
Clearly. So there's always an ethical dimension to this type of question.
Absolutely. And for me, I take that very seriously in my role as a lawyer.
And I think probably, William, you have the same type of situation when you're dealing with wills.
Any notarial documents, actually, we have an obligation to make sure that the client understands what they're signing.
Right.
Which is, it's tantamount in my profession. So, similar to what Marion and Alain touched on, this idea of consent, and not only consent, but an informed consent, because again, one of the, if I can go back to my earlier slide, one of the aspects of a notarial deed is that the capacity of the parties is presumed, and within capacity is their ability to understand what they're signing.
Quite. So to wrap it up, I'll go back to Danny, since he has the Halakhic last word. How many weddings have you officiated at?
I am just thinking about it now.
And how many people actually understand what's written in the ketubah?
I feel very guilty. I have to tell you right now, terribly guilty, because I have to tell you, there's a running joke that I always say also under the chuppah. I said, sometimes they're like, the khatan is very wise. Sometimes it's like the doctor or a lawyer and I'm looking at them and I said, I still cannot believe that you signed this document without really reading it and finding out exactly what's in it. And you just signed blindly. Because truthfully, when you look at the ketubah, it's all written in Aramaic. It's all, it's very difficult to decipher. But we as clergy, as much as the khatan and the kala themselves and the people, the witnesses that are signing this ketubah as witnesses, do not really understand the gist of it, because there's so many technicalities in the ketubah that if it did go to a legal court and they could look at it, they could decipher it, and it could very easily, there's a lot of nuances in the ketubah, and there's many texts in the ketubah. Some people just look at the decor, they love the ketubah, they love the And I always tell them, look at the text very carefully. There's the Castilian text, there's the Ashkenazi text, there's the Sephardic text. Moroccan texts are very different from different cities in Morocco. So no, we don't know what's really in the ketubah, that unless you sit down and you learn what's inside and really get the words. I feel guilty because I know, I do explain to them, and the only way I could explain to them is this way. The ketubah is everything the khatan owes the kala, and that's all it is. Whatever it is, the groom owes the bride, monetarily, clothing, Visa card, whatever it is, you have to give it to the kala, and that's all. And if he understands,
That's been my experience.
yeah, and if he understands just that line, that everything you have and everything you own is to the kala, and if he picks up that handkerchief and he lifts it up over his head, it's a done deal. It doesn't matter what's in it because he accepted the fact that everything that is in the ketubah goes to his bride.
Okay, so the purpose of this evening was not to give you a guilt trip,
Yeah.
but it's maybe to remind you that the kala and the khatan have a right to understand what's in the ketubah.
Absolutely, but they don't want to
Moving
know.
forward,
Excited.
the next wedding you perform, you're going to pay more attention to making sure that they understand what their obligation.
You know what? I hope this is not going to be transmitted all over the place because I have a lot of weddings coming up. They're going to see this. You know?
Okay.
Love is blind.
Real issue here.
I'd like to thank everyone for your presentations, for your participation, for the lively discussion. I know it took a lot of time to prepare these things, and it's greatly appreciated, not only by those who are present today or this evening, but those who will have the opportunity to watch this on YouTube afterward.
Jim, if I could just also interject a little bit, and moving forward is to make a plug for our final session.
That's exactly what I was going to make a plug too, but I'll leave it up to you. Go ahead.
Okay, so our final session will be, please God, on Monday, August the 2nd, at the same time, 7 o'clock, and it involves engineering and architectural professions. We have 3 speakers. Well, Jim, again, will be the moderator. I will be speaking on civil engineering. Sean Corrin has agreed to speak on software engineering. And our final speaker before Rabbi Pinto will moderate and give the Halakhic resource. Our final speaker is Professor Avi Friedman, who will be speaking as an architect. So I'd like to invite you all to return and to also broadcast this message and inform your friends and colleagues about the next session. Thanks. Thanks, Jim.
Thank you all very much, and good evening.
Thank you, Jim and Ron,
Thank you.
for allowing this opportunity.
All the very best to all.
Much amazing.
Just in time for the second period.
Go ahead. Go Habs, go Habs.
Yeah, thanks very much, everyone, for attending.